Mr Speaker, I commend this bill to the House.
The question is that the motion be agreed to. Charles Cheval.
Thank you, Mr Speaker. Mr Speaker, the Sentencing Act contains a number of instructions from Parliament, which is the supreme lawmaking body in our system, to the judiciary as to how that branch of government should carry out one of its most basic responsibilities, the sentencing of convicted persons. Section 7 of the Sentencing Act sets out the purposes which this Parliament tells the courts it ought to observe in conducting the act of sentencing. Section 8 sets out the principles that the courts are to take into account when sentencing or otherwise dealing with offenders. And Section 9.1 lists factors which the judges are to take into account as aggravating ones when dealing with the exercise of sentencing. And I want to list some of the aggravating factors that are currently in the Act so that members have a clear understanding of the context of what is being done in respect of this amendment. One of the first aggravating factor is the actual or threatened use of violence in the conduct of the offence, or the actual or threatened use of a weapon. The offence, if it involves unlawful entry into or unlawful presence in a dwelling place, will be aggravated. If the offence was committed while the offender was on bail or still subject to the sentence of the court, that will also be an aggravating factor. The extent of any loss, damage or harm resulting from the offence, particular cruelty in the commission of the offence, the abuse of a position of trust or authority in relation to the victim, or the vulnerability of the victim by reason of his or her age or health, or because of any other factor known to the offender, is also an aggravating factor which a judge must take into account on sentencing. Now, Clause 5 of this bill will add a new aggravating factor to Section 9.1. And I'm going to read the aggravating factor that we're contemplating here. We heard the Minister refer to it briefly in her speech. It is that the victim, presumably the victim of the offence in question, was a constable or a prison officer acting in the course of his or her duty. So that is expressly said to be a factor that the courts must take into account. And this is in response to, we learn from the regulatory impact statement, a 13.9% increase between fiscal years 04-05 and 08-09 in assaults on police officers, and a 56.3% increase in assaults on corrections officers over the same time. Mr Speaker, Labor did not oppose this amendment on first reading, and our members listened carefully to the evidence at the Select Committee. We will not oppose this bill at second reading because it seems to us that it's a measure that can do little harm. But the question we really need to be asking ourselves at this juncture is, will the bill do any good? Because it stands to reason, if there has been a marked increase in assaults on police and corrections officers over the last 5 or 6 years, then we have a problem. But we also need to not ignore the evidence. And the evidence is this: there are already a number of specific offences that exist on the statute books in respect of violence against uniformed service persons in the police or the corrections service. For example, there's already provided a maximum of 14 years imprisonment for using a firearm against any police, traffic or prison officer. It's already the case that there's a maximum of 3 years imprisonment provided for the aggravated assault of a constable in the execution of his or her duty. Under the Summary Offences Act, it's already the case that 6 months imprisonment is prescribed for assaults on a police officer And again, in the Summary Offences Act, there are provisions, special provisions for resisting a police officer, a prison officer or a traffic officer with a maximum penalty of 3 months imprisonment. There's already a special regime in place. We put it in place to punish, in particular, assaults on frontline responders. And yet we still have this big increase in assaults on them. That would tend to tell us that whatever appears in the law relating to sentencing isn't a big deterrent to those who choose to assault police officers or corrections officers. And the regulatory impact statement actually recognises that this is an act of this Parliament that leads us very close to window dressing. I'm going to read what's said in the regulatory impact statement. The proposed amendment will not require the court to take any specific action in terms of the type or severity of sentence imposed. The court will be required to take this factor into account, along with other specified and unspecified aggravating factors, in arriving at the appropriate sentence to be imposed in a particular case. Because judges' assessment of aggravating and mitigating factors are not amenable to empirical analysis, and the proposed amendment does not entail specific action by the court, no monitoring or evaluation of the proposed amendment is possible. As noted above, the government has decided to undertake the proposed amendment to the Sentencing Act, but the narrow and specific nature of the proposal has restricted the range of options that can reasonably be considered. Sir, the problem here is that the Minister has seen a practice that she rightly wishes to condemn. Nobody can support an increase in assaults on frontline responders. But then, as so often happens in this Parliament, the response that has been employed is suspect. It isn't evidence-based. In fact, we know that there's no way to tell whether or not all the parliamentary time that we're now devoting to this measure will make one jot of difference to the safety of police or corrections officers. And when we're in that situation, we just need to ask ourselves why we're doing this, whether it's all about responding to particular interest groups and particular folk on a certain end of the political spectrum, or whether we're actually sincere in trying to legislate a solution. And there are other questions, sir, about this bill. What about other first-line responders, like nurses and ambulance officers, who are also in danger of assault in their workplace? Why not provide for them in this sort of legislation? And I think it would be an appropriate thing to consider amendments of that nature in the Committee of the Whole if this bill proceeds to that point. And I think it's fair to say, sir, that as far as the cynicism inherent in this measure is concerned, the government knows what it's doing. This legislation has hardly been rushed through the House. It had its introduction on the 13th of October 2010 and it's wended its leisurely way through the processes of the Parliament since then. Clearly the government doesn't feel there's any urgent need to move in this way. And sir, that's been sadly typical of the key government's approach to law and order. Engage in window dressing, engage in legislation that sounds good on talkback radio and in sound bites, but that makes no difference on the streets. And if we want any evidence of that, we can think of the 3 strikes legislation. We can think of the stalled alcohol law reform legislation. Labor will repeal it. That's right. Labor will repeal all non-evidence-based measures that do not make one jot of difference to public safety. And 3 strikes, the stalled alcohol law reform, all these measures have a common genesis, sir. They are done because they are something that can be rehearsed in public and there can be chest beating about it, but actually there's very little difference to law and order that is made in the end. Now, at the same time, important measures like those defining the search and surveillance powers of our police languish on the order paper. We have a new Minister of Justice. She has the opportunity of making a new beginning, sadly, but perhaps not surprisingly, we aren't seeing it.
Call Dr. Cam Calder.
Mr. Speaker, it's a great pleasure to rise and speak on the sentencing aggravating factor.